Paymon who?
Mata Heyday.
Paymon Lata Heyday. Who is he?
Never paid taxes in 30 years. Fought the U.S. tax court and won.
See, I believe our rights come from God, not from government. Hello to my truth and freedom-seeking friends. I am Paymon Mutahede, the president of Freedom Law School, which I created in 1996. And for over 30 years, I have not filed or paid even $1 of income or payroll taxes, and I've taught Americans like you to do the same legally and safely. In this presentation, I will cover the topic of real estate. That's right. If you sell your real estate, whether it's your primary home, whether it's another personal property you own, or business or commercial real estate, when you have that property being sold, when it goes to title or escrow closing that transaction between you and the buyer, the escrow or title company typically wants you to fill out some paperwork like the ones I got here, okay, that you will see, that requires you to sign things under oath that everybody just signs and no question asked. But legally and technically, they are wrong. You should not fill them out. And better yet, no 1099 form should be issued about the sale to the IRS whatsoever.
Wow.
And that is all from U.S. government's official legal websites. Not my opinion. Hang in there, you'll see it. Now, this is a little bit of a longer presentation and more detailed. So I suggest you put it in your car, listen to it as much as you can, in a couple, 3 travels to you back to home and work, okay? And then over the course of a couple, 3 lunches or dinners, perhaps watch it to make sure you really get it deep, because it's mind-blowing. I don't care if the real estate you're selling is only your $200,000 little condominium or $2 billion commercial real estate. You owe no income tax, no capital gains tax of any kind whatsoever to the federal government, and a 1099 should not be sent by the escrow title company to the IRS. Okay, and I'm going to show you how we're going to present this to the escrow title company, the basics of the law about it. Now, these title companies, I've noticed, and escrow companies have come up with different kind of forms of their own. They're not the same. They get their law wrong. That's the most common thing I can tell you they do, is they get it all wrong. The law is right here, Internal Revenue Code. This is the Bible of the IRS. This is what you'll be seeing, okay, on the screen, the online version of it, as well as Supreme Court cases, okay? So this gobbledygook of confusion, which is deliberately done like this, will be cut through, sliced through, made easy to understand. But you got to follow the things, because they use terms that mean one thing to you, but in the law, they mean something else. Then they do that again, another term, like trade or business, or United States, okay, or non-resident alien. What they mean to you in ordinary term, those terms are not the same in tax law, okay? So you see, by using a correct definition according to the law, now you see where you owe 0 income tax and no reporting of any kind about your real estate transaction in the 50 states of America should be in any way reported to the IRS. So with that, let's go and show you this, a typical one of these letters I've got. By the way, we've done this successful, these letters, and we've stopped the escrow company for issuing those 1099s to the IRS legally and safely by what? following U.S. government's official legal websites, which are attached and quoted to these letters that we send to the escrow title company. So this is not some theory. We actually done it successfully. And if you want us to help you with your transaction, we can do that if you become a member of our Restore Freedom Plan. But we're going to put as much as possible on our website, freedomlawschool.org, for you to understand it and do it yourself if that is your choice. Okay? So here we go. This is a sample one. They want you to fill out this substitute form 1099S. Okay? And they claim that this important tax information is being furnished to the Internal Revenue Service as required by Section 5121 of the Tax Reform Act of 1986. They believe that tax laws apply to you when they don't apply to you or your transactions, okay? And then what they do, of course, they'll tell you have to sign things under penalties of perjury. Under penalties of perjury, you have to certify all these things, like you are a U.S. person when you're not a U.S. person for tax purposes, okay? So all these things, they're problematic. We're going to show you. You don't have to fill out these forms, okay? You got to let the escrow title company know this is wrong. And so how do you do it? Here's another one of these forms. Again, another 1099S input form, okay? They want to fill out all this information because they want to issue 1099S forms to the IRS about the amount of the contract sales price, $200,000 or $2 billion. None of that. These forms apply to you, as you'll see, okay? And guess what? Look at this. Under penalties of perjury, under oath again. They want you to say all this kind of information. They claim that you are required by law to provide the settlement agent, okay, with your tax ID number, all these things. You don't, okay? As you'll see, none of this stuff applies to you all in the first place to fill out, okay? So they give you more instructions, but these instructions are wrong, except they tell you in this one, it is important that you consult with a tax professional before completing the 1099S input form to ensure compliance with IRS regulations. Well, that's fine and dandy. I agree with that because, the law doesn't apply to you. The problem is these tax professionals, most of them are completely ignorant of the law. They just do whatever somebody has told them to do, to play by this book, act as if this applies to you, their clients, when it doesn't apply to you at all, okay? So we're going to go straight to U.S. government's official source of law. U.S. Code.house.gov is where the laws are published by the House of Representatives as notice to the whole world what the law is. And that's the best source we can go to. But before that, we're going to go to the IRS website, irs.gov. They have a page, am I required to file a Form 1099 or other information return? And the answer IRS tells you, correctly I may add, is that you are not required to file information returns such as 1099 on other people. Okay, you're not required to file the information returns if any of the following situations do not apply. You are not engaged in a trade or business. You must be involved in a trade or business as defined in the tax laws. Okay, otherwise, if you're not involved in the trade or business, do not ever issue a 1099 to anybody out there. But are you, as a business person, a commercial business of some kind, involved in the trade or business? No, you are not, as defined in the Internal Revenue Code, the federal tax laws, as you will see here now. Okay? So here we go. Let's look at the laws. As I said, at uscode.house.gov from Title 26, Internal Revenue Code. Okay? Section 7701, definitions in Title 26 U.S.C. 7701, Chapter 79, definitions. It tells us, when used in this title, again, Title 26, the Internal Revenue Code, they define many mundane terms that normally you would think they do not need any defining, but they specifically define Even the term person has normally in this definition, okay, where we're not otherwise distinctly expressed. So you see some chapters, sections that that these definitions do not apply, but generally they do, unless they tell you specifically it doesn't apply. Okay, so we're going to go down and look at the term. Okay, trade or business. That's right. Trade or business has this very interesting definition. The term trade or business includes the performance of functions of a public office. Wow. No commercial business of any kind is listed here at all. It's on purpose. If they wanted to list commercial businesses in here, Congress should have listed it, but they chose not to. I'll show that to you. But first, let's go to U.S. Supreme Court in the case of Stenberg versus Carhart that came out in the year 2000. And here's a rule on definitions that the Supreme Court tells us that when a statute or law includes an explicit definition like what we just saw, we must follow that definition even if it varies from that term's ordinary meaning. Yep. What you and I think what the term means is out the window. We're going to go by what the law specifically and clearly says only. And it is axiomatic, which means self-evident, obvious, that the statutory definition of the term, what's defined in law, excludes unstated meanings of that term. Something is not defined, okay, in the definition is not there. It's simply not there. Very simple, right? And when it comes to taxes, it's even more obvious. Like the Supreme Court is a source of all this information. Gould versus Gould is a unanimous 1917 tax case decision of the U.S. Supreme Court. And here's what it says. In their interpretation or understanding of statutes, laws, levying or imposing taxes. So, in understanding laws that impose taxes, okay, it is the established rule not to extend the provision of tax laws by implication or implying beyond the clear import of the language used, like 50 states are not listed, in the definition of the United States. Trade or business does not include commercial trade or business. It just includes performance and functions of public office. That's all it says. Or to enlarge their operation of tax laws so as to embrace or include matters not specifically pointed out. Something not specifically pointed out in the definition, it is simply not there. Okay? And for good measure, the Supreme Court reminds us of this very important thing at the end, that in case of doubt, the tax laws, are construed or understood most strongly against the government's power to tax and in favor of the citizen not being taxed. Not just strongly, most strongly against the government's power. So you can't get any stronger, not most strongly, can you? No, you can't. So trade or business only means performance and functions of public office, okay? Now let's look at this, folks, to give you a contrast. How in the Council of District of Columbia, this is District of Columbia laws, okay, right now in existence right now. Chapter 18, Income and Franchise Tax, okay, of the Code of District of Columbia. They have a definition right now in Chapter 47, 1801.04. They define many different terms here in these laws that apply to Washington, D.C. For the purpose of this chapter, unless otherwise required by context or term, right? And they go down the term trade or business. Trade or business means engaging in carrying on of any trade, business, profession, vocation, or calling, or commercial activity in the District of Columbia. Look at that! Okay? They mentioned commercial activities clearly and specifically, okay? Including activities in a district that benefit the related entity of the taxpayer. The performance of the function of a public office is also there. See, the government work isn't there. The government work is right there. But, look at this. Commercial activity, okay, is also specifically there because they intended it for it to be there. So you know when you see it right here, trade or business in the federal tax laws does not include you as a businessman, your commercial business. It only includes performance of function of public office. That's all it is. So with that understanding now, we're going to go to the next part of the presentation. We're going to use this understanding of those definitions to explain things to you a little bit more. Pieces are coming together. So hang in there, okay? These pieces are coming together little by little as we go on. So the section of the law that they refer to these people, these real estate agents, are being closing escrow people, is return of brokers, section 6045, okay? Now, we're going to go down in section 6045, way down to E2, real estate reporting person, okay? For the purpose of this subsection, okay? This subsection is what? Okay? Subsection is, there we go. What they have right here, okay? Subpart, right? Subpart B, information concerning transactions with other persons. Okay, that's what they're relying upon. Okay? The term real estate reporting person, which the key term means any of the following persons involved in the real estate transaction in the following order, okay? At the person, including an attorney or title company, responsible for closing the transaction. And that is what title companies see. They say, oh, that's us. We got to do this thing. We are a title company. We are an escrow company. We're doing this kind of thing. Attorney closing escrow transaction, a real estate transaction. We have to do this. But it's not them. They're just being deceived, and they don't read the law as they should. Continue reading. Watch, okay? Going to get more interesting. Okay? It includes also the person, including, okay, the mortgage lender, sales broker, buyer's broker, or such other person is that designated in regulations prescribed by the secretary, okay? And also, here's the important part. Any person treated as a real estate reporting person under the preceding sentence shall be treated as a broker for the purposes of subsection C1. Oh my gosh. Now they're throwing us to subsection C1. Real estate reporting person, you have to go up to C1. Guess what, guys? Sorry. We got to go up to C1. This is what they do this deliberately, okay? Because you want to go look up what is that they're talking about there. They're hoping you just give up. And that's what the typically title companies, escrow companies, charities give up right there. They don't bother looking it up. We are. And that's where the freedom for you lies, okay? So here we go. Let's go to C1 now. So 6045 C1, here it is. Definitions. For the purpose of this subsection, broker, the term broker includes a dealer, a borrowing exchange, and any other person who, for consideration, regularly acts as the middleman with respect to property or services. Okay. And a person shall not be treated, okay, as a broker with respect to activities consisting of managing a farm on behalf of another person. Okay. So here we are. The term broker is in the game. What is a broker now? Right? It includes, let's go just a little bit deeper, okay? Here we got why broker matters, because here, the beginning of section 6045, we've been reading, this is the section we've been reading, the first part, it says, every person doing business as a broker shall, okay, when required by secretary, make a return, and according with such regulations, the secretary may prescribe, show the name and address of each customer, with such details regarding the gross proceeds and such other information as the secretary may by forms regulations required with respect to such business. This is what, again, the title companies think that because of this, they have to, at the closing of the real estate transaction, get a 1099 information to issue a 1099 to you and some other bunch of stuff. Okay, now, the next part will clear up all this stuff I'm going through. Does it make sense? Hang on, it's going to make sense. Just stay with me, okay? Hang in there. Here we go now. This is section 6045, the term person. Okay? So listen, we're talking about that every person, right? Well, what's a person? You think every person would be everybody. That'll be you, that'll be me, right? But who is every person they're talking about here? Surprise, surprise, 6045 tells us here in C4. Wow. The term person includes any governmental unit and any agency or instrumentality thereof. Amazing. Jawbreaker. They're not talking about people, regular people. They're talking about government offices and government workers. But these are all federal government workers and federal offices, not someone from Russia, China, England, California, Florida, Texas. No, this is only the District of Columbia that it applies to, and Virgin Islands too, I think, as you'll see. Okay, see the whole thing doesn't apply to anything except government units, government people. Okay, which you're not. Your title escrow company is not. Do they perform this thing? No, this is not the title company. The title company is not doing any governmental work or whatsoever. Okay? So this applies to, for example, the Federal Reserve Board, to the Post Office, to the FBI, to the Forest Service, these kind of things. Let's continue now to here, to another one of these forms they give people to have you be a slave. Seller's affidavit of non-foreign status, okay? They say if you are a non-resident alien, do not sign this document, okay? Well, non-resident alien with respect to where? 50 states or Washington, D.C., you shall see. The law they quote is Section 1445 of the Internal Revenue Code provides that a transferee of a U.S. real property interest must withhold tax if the transfer is a foreign person. Okay. Well, you think, I'm selling my real estate, okay, transferring my property to somebody else, so that is me, right? I'm a seller of the transfer, right? No, they're not talking about you, because it depends on the term United States now. Let's take a look at that, okay? The term United States is key, because they're talking about a U.S. real property. That is not your home. This is not your business or personal property or commercial interest in the 50 states. This is the U.S. is not the 50 states real property, okay? Let's go look at the definition of these terms, right? Here we go. Here's Section 1445. What does it actually say? Okay? Withholding of tax on disposition of United States real property interest. You'll see it's only D.C. and the Virgin Islands, but you'll see. Hold on. It says, except as otherwise provided in this section, in the case of any disposition of United States real property interest. Oh, as defined in Section 897C. That's key. We have to come back to that. By foreign person, the transferee shall be required to deduct and withhold a tax equal to 15% of the amount realized on the disposition. Okay. So let's go on this search, folks, okay, to Section 897, right? Here it is, Section 897, disposition of investment in the United States real property, which is not the 50 states. I'm telling you, you'll see, okay? Let's go down in this section now further to 897C, as we just read, right? Okay? So it tells us, for the purpose of this section, United States real property interest, okay, except as provided in subparagraph B or subsection K, the term United States real property interest means an interest in real property, including interest in a mine, well, or other natural deposits. Such specific they got here, right? Look at it in the United States or the Virgin Islands. And a bunch of other nonsense stuff that doesn't really matter, right? Now, you think, okay, why United States and Virgin Islands? Why not Puerto Rico mentioned there? Why not, you don't have Guam mentioned in there, or any of the 50 states? For a good reason. Because the United States does not in tax law include the 50 states. Let's continue on, as we shall see. Let's go to Section 7701 of Title 26. Definitions, we talked about this. When using this title, were not otherwise distinctly expressed or manifestly incompatible with the intent thereof, go down to United States estate, and voila, you don't see any of the 50 states in here. It's only the District of Columbia. Yep. Look at the term state. Shall be construed to include the District of Columbia, which is not even a state. How can they define the federal government, District of Columbia, to be a state when D.C. is not a state? Because they can. So they do. So here we are. D.C., okay, is state. And states multiple, plural of that is the same thing. 5 states, 5 D.C.s, or 100 of them. It's the same thing. And therefore, when you see United States, when used in a geographical sense, it includes only the states, which is D.C., District of Columbia, and again, the District of Columbia. That's all it is. It all applies to District of Columbia and Virgin Island real estate. That's what U.S. real estate means, not the 50 states that the title and escrow company and attorney lazily assume. They assume it applies to 50 states. It doesn't apply to 50 states. Get it? So, we're almost done. People hang in there. Okay? So, listen, I want to show you something. For nationality purposes, okay? Title 8, aliens and nationality, all of us, you, me, we're all state citizens and U.S. citizens. For every different category of law, they could be different definitions of the same term, okay? So here it is, Chapter 12, Immigration and Nationality, right? I'm a naturalized immigrant. Most of you are born in America. You're national born American. Look at here, 8 USC 1101, 38. The term United States, except as otherwise specifically here and provided, when used in a geographical sense, means the continental United States, Alaska, Hawaii, Puerto Rico, Guam, the Virgin Islands of the United States, and the Commonwealth of the Northern Mariana Islands. See? By the way, people from American Samoa are not on that list, interestingly enough, specifically left out. Okay? So you see how they use these definitions, and they don't define them, so let you assume what they want you to define. Okay? And that's how they get you, by ignorance of us. And the truth was hidden all in plain sight in the law books that the title escrow company never looked up, attorney never looked up, you never looked up, but now you see it for yourself deciphered, all the gobbledygook, to see how it doesn't apply to you or your real estate transaction at all whatsoever, my friends, okay? So here we are. Let's get back to this. We go back to section 897, disposition of investment in United States real property. So now we know it's D.C. and Virgin Island property that you're selling. If you have real estate in D.C. or Virgin Islands, you sell it, this applies to you, to your real estate. Otherwise, no. So look at what it says. Treatment as effectively connected with the United States trade or business. Okay. Effectively connected with Washington, D.C. government work. See, United States is D.C. Trade or businesses, government work. So treatment as effectively connected with Washington, D.C., District of Columbia government work. Federal government work. For the purpose of this title, Title 26, gain or loss of a non-resident alien, someone not from D.C. Oh, I got to come back to this non-resident alien. What is that? Let's pause there. Okay? There's definition for that in section 7701, way down to B, definition of resident alien and non-resident alien. Okay? For the purposes of this title, other than Title B, look at non-resident alien. Boom, there it is. An individual is a non-resident alien if such individual is neither a citizen or resident of the District of Columbia, nor a resident of the District of Columbia within the meaning of subchapter A, which is, we just read. Yeah, United States means D.C. So if you're neither a resident, okay, of D.C. or citizen of D.C., you are a non-resident alien of D.C. So that makes me from Florida a non-resident alien in D.C. because I do not live in D.C. or nor am I a resident of D.C. Same thing with you in the 50 states. All of you are non-resident aliens to D.C. So anybody from Russia, Egypt, Japan, they all are non-resident, not just you and I, to Washington, D.C. So now that we understand that, non-resident alien means someone not from D.C., let's go back, okay, to what we were just reading earlier, to section 897. So for the purpose of this title, gain or loss of someone not from D.C. individual or foreign corporation, not from D.C. corporation, from the disposition of a United States, that's D.C. or Virgin Island real property interest, shall be taken into account in the case of someone not from D.C., okay, under section 871B1, or in case of a foreign corporation under section 882A1, okay? Okay, as if the taxpayer were engaged in the performance of function of public federal government work within D.C. during the taxable year, as if such gain or loss were effectively connected with such government work. Now, sorry guys, it's got a little bit too complicated, a little bit too gobbledygooky. I want to make it easy for you to translate this thing, okay? So let's go to the next ones. I'm going to make it easy for you to understand, okay? We have to go now to section 871B, right? Because we refer to that. So what they're saying basically, if you are selling real estate, okay, in Virgin Islands or the District of Columbia, it's going to be taxed the same as somebody under section 871B doing federal government work in the District of Columbia. That's what it says. Now let me get that more clear for you folks by going to 871B1 to begin with. Okay, here it is. Okay, we covered non-resident alien. Okay, here it is, 871. What a gobbledygook code. This is code, folks. I've decoded that for you. Okay, 871B1. Income tax connected with the United States business graduate rate of tax. Look how this thing is code. This ridiculous thing is. Tax on non-resident alien individuals. That's who? That's a person not from the District of Columbia. That's what it really is, right? A non-resident alien individual, which means a person not from the District of Columbia. Engage in trade or business, which is what? Someone performing functions of federal public office within the United States, within the District of Columbia, during a taxable year shall be taxable as provided in section 155 on its taxable income, which is effectively connected with the conduct of a trade or business, which is what? Performing functions of a federal public office within the United States, within the District of Columbia. Gosh, what a mouthful. What a mouthful for, really. But they do it deliberately to confuse you. Who takes the time to go through and decode all this? Go here, 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 and this refers to here, that refers to that, that refers to that. Now put it all together like, I give up. That's why these attorneys, lazy, they give up. And they just write these instructions for the escrow title companies, which are completely wrong because they don't get into it. Okay? Now let me make it for you a little bit easier, okay? Yeah, let me tell you something. This is very important that you get this. Because when you're filling out this form, they are wrong. And they want you to sign up under penalty of perjury that your real estate is from District of Columbia or Virgin Islands. Yeah. And the title company, is a federal government unit. That's right. The title escrow company is actually saying that they are doing their unit, because that's a person in that law, okay? For a government unit that they're doing all this stuff. None that applies to you at all in the 50 states, okay? So all the stuff that showed you, if you don't follow, like I tell you, you're going to be potentially in trouble. Why? Because you lied under oath. The penalty of perjury. All these tax forms, tax-related work, are all under penalty of perjury under oath. So if you sign these forms, you could be in trouble legally. Absolutely. Take a look at this. Here's the law. Okay? Title 26, Section 7206, fraud and false statements, okay? Any person willfully makes or subscribes any return statement or other document, okay, which contains and is verified or written by declaration that it is made under penalties of perjury, and which he does not believe to be true and correct as to every material matter, right? Or aids or assistance, willfully aids or assists, or procures, counsels, or otherwise advises the preparation of a presentation under or in connection with any matter arising under the term of the laws of a return, affidavit, claim, or the document which is fraudulent or is false as to any material matter, whether or not such falsity or fraud is within the knowledge or consent of the person authorized or required to present such return, affidavit, claim, or document, or, gosh, all this stuff, guess what? You know what this is? Here it is. Shall be guilty of a felony. And upon conviction thereof, shall be fined no more than $100,000 or in prison not more than 3 years, or both, together with cost of prosecution. These forms do not apply to you. When you sign these forms, right, you just committed fraud. And the title escrow closing company, they also committed fraud. Under what I just read you, rewind this and read it for yourself. Okay? You don't want to do that. Neither do they. So you're saving them by getting counsel and looking up the law for yourself from the government's official legal websites. Straight from the horse's mouth at uscode.house.gov. You saw everything for yourself, the U.S. House of Representatives. And if you sign a form, it can get even worse for you and a title escrow company and attorney and the clerk who's doing all this. Because there's another federal law that you should be aware of, okay? Because here it is, folks. We have this first law is what? Fraud and false statements. That's a federal law. Here's the second one. There's a law called conspiracy to commit an offense or defraud the United States. Yep. If two or more persons conspire either to commit any offense against the United States, okay, guess what? Like right now, if you do this form, you commit tax fraud, that's an offense against the United States. And this law says two or more of you get together to do tax fraud, but you fill out these forms that you should not fill out at all. You're both involved in conspiracy to violate federal law. That's what the law says. Let's go look at it a little bit closer together, okay? So remember, two or more persons conspire to commit any offense against the United States, like what you just saw, okay? Okay? Or defraud the United States or any agency thereof in any manner or for any purpose. And one or more of such persons do any act to affect the object of the conspiracy, like they had you sign that these false forms, right? Each shall be fined on this title and imprisoned not more than 5 years or both. Whoa, whoa, whoa. 5 years, folks. 5 years. On top of the other 3 years, you can go to prison. 8 years. Because they deceived you to sign this form, because they were deceived. The title escrow company, the attorney did not know. You're doing them a favor by explaining this stuff to them. I don't want to get in trouble, neither to you. And let's get the best counsel we can. U.S. government's official legal websites. That's why we have these forms. By the way, we've done this, like I said, for our students, okay? You want to go, and we're going to put these on our website, these sample of these letters. But I've seen title companies, there's a little bit different misreading of the law. So you have to read, you got to get the title closing documents right away from the title company or escrow company immediately, and see it and decipher that nonsense, okay? And see exactly how you're going to show whether they got it all wrong. There's not one size fits all necessarily. Unfortunately, it's not the case. I've done 3 different people so far, on this thing, and every one of them is a little bit different than the other one. The title companies, they do a different way of getting the law wrong. So, but I'm going to show you some samples we do have on our website. I'm going to put it on there so you can check it out, okay? Here's one of them. This is the newest version, okay? That we did on this thing for this person, okay? So We blacked out information about this person, about 1099 input form. So this kind of stuff I read to you, okay? It's all in these sample letters we're putting on our website, okay? So as much as I want to give you guys the ability to do it on your own, if you do the real estate transaction, which we ought to do, get it done right, become a Restore Freedom Plan member. We make sure it's done right for your real estate. That's right. And there will not be 1099 on you at all. Everything done right from the get-go. So as a Restore Freedom Plan member, that's one of the benefits that you get. Make sure that everything is done correctly for you in the first place, whether it's $200,000, $2 million, or $2 billion real estate transaction closing that's going on. Okay, so with that, go to freedomlawschool.org. Okay, educate yourself about all these, what we do. Okay, remember, none of the people in 50 states or any federal income tax. The only people that got to pay federal income tax are who? Citizen residents of District of Columbia, federal workers that work in D.C. Now we see that if you have real estate in D.C. or Virgin Islands, you got to pay income tax and that as well. So, I love you folks, and I want every one of you to be able to live free. But the truth is, I cannot do it for you. Only you can do it for you. And that is, you make the priority. When you get in your car, put your smartphone up, okay? And as you watch a road, drive safely, listen to what you're hearing, couple, 3 times on your drive. Then when you get to home or office, at lunch or dinner, put your smartphone or personal computer up, watch it this time, and you see, verify it's all true, then you're going to see, oh my gosh, why I was paying all this money, millions and millions, billions, some of you have been paying income tax. Donald Trump been paying billions to the IRS unnecessarily because he didn't know how corrupt and criminal the swamp was. It's far worse than the FBI, CIA, NSA, DOJ. Okay, the IRS is a master deceiver of all these government agencies, but you are free, more free than Donald Trump, folks. So help him. Let's defund the swamp from within. He's from the top. Try to defund the swamp, and you defund it by not paying federal income and payroll taxes and corporate taxes that you never legally owed in the first place. Same thing goes with real estate transactions and crypto. You owe zero on all that. Stocks, bonds. This is a free country if you educate yourself. So with that, I love you all again. I want you to share with other people, okay, so that other people have a chance, your friends, family members, to be free just like you. And together we can work together, have America be a free country once again. Thank you for watching.